Bump, bump, bump in the night and bump stocks. We're here with Stephen Halbrook to talk about bump stocks and where is that Supreme Court litigation going? We know there's 2 cases before the U.S. Supreme Court. They've had that for many, many, many months, which strongly suggests something exciting is going to occur this fall. We're going to discuss bump stocks and the ATF history of regulations of such types of devices, including some other so-called machine gun devices. You're not going to want to miss this in just 1 second. Hey folks, I'm Mark Smith, host of the Four Boxes Diner, member of the United States Supreme Court Bar, constitutional attorney, best-selling author, and proud American gun owner. If you have not subscribed to the Four Boxes Diner Second Amendment channel, please do so and show your love for the right to keep and bear arms. And please feel free to join us on Twitter, where we now are, to help broaden the scope and make this channel more popular than ever before. So, Stephen, we know that right now there's 2 Supreme Court cases pending involving so-called bump stocks. Those cases pending before the Supreme Court, as I understand, don't involve the Second Amendment directly, but they involve the authority of the ATF to really make it up as they go along and redefine firearms as redefine really bump stocks as machine guns. So, Stephen, how on earth can the ATF make the case that these pieces of plastic that are bump stocks somehow fall within the definition of machine guns under the NFA?
Well, let's start with the definition of machine gun, 26 U.S.C. 5845B. A machine gun is a weapon that shoots more than one shot automatically by a single function of the trigger, that is designed to do so or can be readily restored to do so. Mind you, not readily converted, but readily restored, meaning that it could fire at one time like that. It also includes a frame or receiver of a machine gun. It includes a part that's designed and intended solely and exclusively to convert a weapon into a machine gun, or that is a combination of parts to convert a weapon into a machine gun, or is a combination of parts from which a machine gun can be assembled. That's Congress passed that. The definition started out in 1934. It was added to in 68 and again in 86. That's what Congress defines as a machine gun. If a bump stock is a machine gun, they need to find that it's a machine gun under that definition. ATF has no business making up a more extended definition. And as a factual matter, for years, ATF said that bump stocks are not machine guns. Look, bump stock is a generic term that can mean lots of different things. You can take any semi-auto firearm, and I don't know how to do it, but you put it against your knee and somehow keep the trigger pulled, and the recoil makes your finger stay on the trigger, but it goes back and forth. And so there's been a lot of different designs and inventions. There was one bump stock type kit where it had springs in it, and so you could keep your finger pulled on the trigger, and the spring action would make the recoil fire continuously without you taking your finger off the trigger. There's a rotary kind of device. So there's actually a manual movement going on for each trigger pull, or for each shot that's fired, rather. And so that's not a bump stock that would be classified as a machine gun. So there's different types of implements, but the one type of bump stock that ATF put in the regulation, you keep your finger pulled back, but you have to keep pressing forward on the forearm of the rifle, and the recoil, when you keep this pressure, makes it fire continuously, but it's by manual manipulation. That's the whole problem here. So the regulation makes these devices machine guns, and what should be done is, if they think that's a machine gun, they can try to convince a jury that's a machine gun under the definition that Congress passed. And if they were to try to do that in a criminal case, of course, all the previous letters that ATF wrote saying that it was not a machine gun would be evidence, and hopefully would lead to an acquittal. But once again, we're talking about ATF as an agency making up and extending the criminal law that Congress has passed, and that's what's illegitimate. That's why it's beyond its authority. And that's what's before the Supreme Court.
And, it's interesting, your case of Thompson Center Firearms with the rule of lenity, which basically says if there's any doubt or any really ambiguity in a law, regulation, statute, whatever it happens to be, then the presumption goes in favor of the individual and individual freedom. Unfortunately, we have a lot of federal judges in America that don't seem to like to do that. They seem to give the presumption and the benefit of the doubt to the government, which, of course, is absolutely backwards in a free society such as ours. And it's backwards to American law and the U.S. Constitution. But of course, you had that big win in Thompson Center Firearms, where you basically, at least thanks to the Supreme Court, taught these federal courts a lesson. But not all these courts are following the rule of your case.
Look, it's that's par for the course. After Heller was decided, you have a rebellion against Heller. You have the courts making stuff up. They're going to adopt the two-part test, and they don't go by the common use test. Even in their opinions, they reject the Heller common use test. And finally, they just got a spanking with the New York case, the Bruin case, where Justice Thomas wrote that 2 parts is 1 part too many. I love that phrase. But the lower courts they rebel against Supreme Court decisions they don't like. And so we're going to have to see where this all comes out. With the bump stock litigation, you've got a number of cases, courts of appeals upholding the regulation, but you have strong dissenting opinions as well. You have a Court of Military Appeals which has invalidated the statute or invalidated the regulation, and that's an appellate decision that's kind of ignored, but it's on the books. So we'll have to wait and see what the Supreme Court's going to do. They could do an opinion where they don't even decide the bump stock issue, but they decide that the courts below improperly used a judicial interpretation that's not right, namely over deference to the agency, and they can bring in the major questions doctrine as well.
Stephen, you said something that was quite interesting as we try to understand, because I wanted then, after we talk about bump stocks, talk about some of these other specific things like lightning links and these other ideas. But before we get to there, I want to make sure I get some general principles nailed down here involving this. You made a reference to manual manipulation. Is manual manipulation mean that when a human being actually has to do something to keep the gun firing bullets? Is that what you mean by manual manipulation? Is that different than like a fully automatic machine gun where once you hold that trigger back, it's going to keep on firing, and that's really mechanical manipulation? You're not doing anything other than holding the trigger. The gun is doing the work for you, as opposed to manual manipulation of something that means you're really doing the work to make that gun fire repeatedly. How does that break down, or did I get that wrong somehow?
Look, the term manual appears in the definition Congress passed. Let me read it. The term machine gun means any weapon which shoots automatically more than one shot without manual reloading by a single function of the trigger. So you've got more than one shot, you've got a separate term automatically, and you have without manual reloading. So what that means is that, a real machine gun, you just hold it, you pull the trigger, it just fires. You don't do anything. And so that's where these cases that are in conflict have come down. To what extent have you manually reloaded? And of course, reloading, that's a very general term. It doesn't necessarily mean putting a cartridge in the magazine or something like that. I mean, frankly, what that went in there for was because, like a shotgun, a lot of these shotguns that were made in the 30s and 40s, you could pull the trigger, a pump shotgun, you could keep pumping it, and you have the trigger still pulled, and it would keep firing. But you're manually reloading it. Every time you pump it, you're putting another shotgun shell into the chamber. So it's got more than one shot, and it's got to be automatically. So that excludes like a malfunction, like what's called hammer follow down, where you have a malfunction in the gun and it fires 2 times and maybe jams after that. So it's interesting how technical some of these appellate decisions have been. when the different judges argue over to what extent is a weapon firing automatically. I mean, just the term automatically excludes manual manipulation, and that's where the courts should be going.
So, Stephen, I want to give you a couple terms that, we people have asked questions about, and you're really the right person to ask these questions of, because to understand firearms law at this level, you need to really understand the mechanics of the firearms, the mechanics of the firearms parts, as well as all these various layers of law. So it's really a very complicated area of life in America, and I'm glad you're here to help educate us on this. But some of the terms that get kicked around here and discussed, and I think a lot of misunderstanding is, there's terms like auto key card, forced reset triggers, drop-in auto sears, conversion kits, CRS auto key cards, jigs, binary triggers, trigger cranks, these kinds of things. Can you just maybe talk a little, break some of this stuff down for us? Like, what are these specific issues that are not bump stocks, and how many of these things really become machine guns or convert a gun into a machine gun? What's the story with these various terms?
So let's bring it down to a practical level. If you're familiar with the M1 carbine, millions of them were manufactured. That was a World War II and Korean War rifle that was used by our forces. It's a semi-auto. An M2 carbine was basically the same rifle, but it had different parts in it. There were 5 parts in particular, but then there were 2 more parts that you would have to use, like a stock with certain cutouts, to make it where it would be a machine gun. It would fire automatically more than one shot with a single function of the trigger. So that those parts, that would be a conversion kit under the definition of machine gun, a combination of parts designed and intended to convert a weapon into a machine gun. Then in the 60s or 70s, somebody designed what was called the AR-15 drop-in auto sear. Basically, the AR-15 was approved as a semi-auto rifle. An M16 was the fully automatic version, which had holes drilled for the automatic sear, and also it was milled out for certain other parts so that you could fire it fully automatically. The AR-15 drop-in auto sear made it possible to put this part into the semi-auto rifle along with 5 M16 parts, and it would make it where it would fire fully automatically. So ATF classified the drop-in auto sear as a machine gun conversion kit. There's another device that was designed, the Lightning Link, where you didn't even have to put in any M16 parts. You just insert the Lightning Link into the receiver, and you could make it fire full auto. So those are conversion kits. Those are machine gun conversion kits.
And Stephen, just to be clear, are conversion kits actually in the statute for what is a machine gun? Are they actually in the statute, or is that something made up by ATF?
No, they're in the statute. Even if it's only one part, like a Lightning Link. Notice the statutory definition included a part designed and intended solely and exclusively to convert a weapon into a machine gun. So that's the Lightning Link. ATF didn't make that part up. But then we come to this recent case about the card. It's apparently a credit card sized piece of metal, and it's got I haven't seen one actually, but it's got not cutouts, but maybe lines to show you where you could manipulate the metal, remove some of the metal, and make a Lightning Link. That's being prosecuted, and whether that's a conversion kit, I would really have to know more. Can you just break the parts off at the outline, and in 1 minute you've got a conversion kit, or is it something? Is it just a piece of metal with a etching on it? In which case, it's not a conversion kit.
And on these points is, at what point does we don't really talk a lot about the First Amendment, which is the right to speak, the right to a free press, the right to free speech. It's longstanding First Amendment law that, you can tell people how to do all sorts of things in book form and writing. You can talk about things. There's Supreme Court precedent on this. So the one is whether or not, you have people on YouTube talking about different things that you can do with your firearms. How much of that is protected by the First Amendment versus how much of that is something that could run afoul of some law? Any thoughts on the role of the First Amendment and free speech in terms of talking about firearm improvement, firearm technology, converting things, anything like this? How does all this play out?
I assume there's scientific manuals on how to make nuclear weapons. I think the First Amendment would protect that. And by the same token, if you have plans or diagrams or writings that explain how to make different things, that's First Amendment protected. Of course it is. The Anarchist Cookbook from the 60s was a famous book for that. I mean, they had how to make explosives and all kinds of weapons. But yeah, it's not unlawful. And so when ATF says something's not a frame or receiver, but if it's got like jigs or if it's got written instructions on how to manufacture or make it into a receiver, that's all First Amendment protected. And until you do that, you haven't done it. And that's why I know in this this card case, First Amendment is one of the defenses to the prosecution.
Yeah, and it is quite interesting when you send people instructions. How is that not protected by the First Amendment? I guess we'll find out as these cases move forward. By the way, isn't there also the case, Stephen, in some of these instances involving so-called ghost guns? If you send raw materials, not the official gun, but if you send raw materials with instructions, does that somehow run afoul and convert a gun kit into sort of a firearm in some way?
That's what ATF is saying with its new definition of a partially complete frame or receiver. You could have the hunk of metal that's partially machined, and ATF might say that's not a frame or receiver, or not even a partially made one. But if it's got jigs or instructions with it, diagrams, things like that, then it is. And that's where that crosses the line. Congress said just frame or receiver. It's got to be made already. It's not a pre-frame or receiver, and that's where ATF has crossed the line into trying to make new law.
And Stephen, you've made the reference to the word jig, and again, not everyone here, not everyone who watches the channel are, firearms technology experts. What exactly is a jig in the context of, making your own firearm or these ATF issues?
Think of it just as something that would act as a vise or some other kind of tool that would allow you to hold something correctly or to drill a hole correctly so that you don't get it out of line. It would just be some kind of metal implement to allow you to facilitate your correct drilling and milling or other manipulation of metal to make it into a frame or receiver.
Stephen, this has been super helpful talking about these issues involving so-called bump stocks and machine guns. We'll see what the Supreme Court says. They're going to have the final word on this potentially, and maybe in as few as 8 or 9 months. We're going to find out what they do in October with these 2 pending bump stock cases and whether or not they're going to use that as the vehicle to cut back on all the authority of the administrative state, including but not limited to the ATF. So, Stephen, thanks again for talking to us about these very interesting gun-related topics.
My pleasure. We need more discussion in the public forum about really technical issues involving how guns are regulated. There's a lot of misinformation out there, and so thank you for the opportunity to discuss this.
Okay, folks, I hope you learned a little bit something about bump stocks here from Stephen Halbrook during this interview. If you haven't subscribed, of course, to the Four Boxes Diner channel, please do so. And again, we'll see you again soon here at the Four Boxes Diner.
Orders up. Table 2A.